I'm recording on the cloud now.
Yes.
So it says recording.
Awesome. Welcome to DC Shorts International Film Festival 2020 edition. I'm Peter Morgan, the DC Shorts Executive Director. This is DC Shorts Workshop Law 101 for Filmmakers with attorneys Brian Frankel and John Mason of Washington Area Lawyers for the Arts, also known as WALA. We're glad you're all here with us today, and I'd like to thank upfront Brian and John for joining us on a Saturday to share their knowledge and experience with everyone. I'd also like to thank one of our major funders, the DC Commission on the Arts and Humanities. This year's festival, which continues through Wednesday, September 23rd, we're screening 163 short films from 34 countries and 20 showcases. So if you have not checked out the website, please do so and purchase some tickets. With that, I'll hand it over to you, Brian and John.
Thank you.
Excellent. Thank you so much, Peter. It's great to be here. My name is Brian Frankel. I work with Washington Area Lawyers for the Arts. I started as a volunteer in 2007, and then I became the education chairperson and also a member of the board of directors. In a previous life, I was a filmmaker. And then when I was sitting in a pitch meeting with a cable network, I looked at my entertainment lawyer and I said, I have the wrong seat at the table. And so after being in the real world for 10 years, I went back to law school, graduated, and got recruited to come up to DC in 2007. And I've been here ever since. And so I launched my own firm in 2011. And then I also became of counsel with a highly esteemed entertainment firm here in DC, probably about 3.5 years ago. And that would be Copyright Counselors with that fellow over there, John Mason. So we volunteer together. We work on a lot of different exciting projects together. And so it's good stuff. And you'll get to hear more, but that's my introduction. I'll hand it over to John.
Hi guys, thanks for having us. Thank you, Peter, and thank you, Brian. I've been doing art and entertainment law for over 20 years. When I got out of law school, it was what I wanted to do. I'm also a literary agent. I have my own firm, Brian's of Counsel. He's with me, so we work on a lot of things together. I basically represent creatives of all types. We do, whether they're filmmakers or writers or photographers, anyone creating something original and interesting. Those are the kinds of people we like to work with. About half of what we do is litigation or disputes, and about half of what we do is transactional, which means contracts, licenses, that kind of thing. I'm also the board president of the Washington Area Lawyers for the Arts. And I want to tell you a little bit about WALA, because WALA is co-sponsoring this with DC Shorts, and has so many years in the past. Washington Area Lawyers for the Arts is the DC area volunteer lawyers for the arts nonprofit. Around the country, there are different volunteer lawyers for the arts organizations. We're the third largest after New York and California. What we do is really twofold. We provide referrals for creatives in the DC area who need legal assistance to pro bono and low bono or discounted rate lawyers, which can be a significant value. I mean, if you can get free legal in a significant dispute or with help with a contract or whatever it is you're dealing with, that can be a real value. We also do, the other prong of what we do is educational programming, just like this. And we put on over 50 events a year, basics in copyright. We do a creative entrepreneur series, which is sort of a 6-part series. So 6 different lectures, nuts to bolts, A to Z on starting a creative venture. So it could cover anything from business formation to tax issues, to contracts, to even negotiation skills. So WALA is the DC area nonprofit that does these things. And if you want to join, you go to waladc.org. It's a low annual membership fee. And if you are a member, You can submit matters to our case list for consideration for our volunteer lawyers. And you can also attend a number of these lectures for free as a part of what your membership fee is. And I can't remember, but I think the membership fee might be $40 or $50 right now, and that's annually. So not a significant investment for a lot of return. Brian and I do these talks frequently, and we've done it at DC Shorts a number of years. And I think he'll agree with me that the one thing we enjoy when we're talking to people who make films, whether you're crew or you're on the camera or you're the director or the producer, whoever you are, you're a storyteller. And that's the way we like to think about you, because what you're doing is you're telling a story in a particular audio-visual medium. And then what we do is try and help you understand the legalities around that so you can do it in the best way and be protected and own what you want to own and give away what you want to give away. All storytelling in under US law is basically falls into one category of the law, one area, and that's copyright. Copyright is going to apply to whatever you're creating that's original. And I'm going to give you the really boring legal definition of copyright. This is always how we start, and then we break down some other issues. Copyright protection subsists in original works of authorship. So it's got to be original, right? You don't own copyright in something you take from someone else. So you have to create it yourself. You're the author or creator. And that's why they use the word authorship, which most people think of an author as a writer, but for copyright law purposes, an author is anyone who creates anything. So it's a photographer, it's a filmmaker, it's a sculptor. So the copyright protection subsists in original works of authorship that are fixed in any tangible medium of expression. That latter part of the definition, fixed in any tangible medium of expression, is very important, because a lot of times people get confused about whether they can own an idea. And generally in our legal system, you can't own ideas. You can only own the expression of those ideas. And so copyright law requires that your idea be fixed in some tangible medium. And that could be putting a pen to paper and writing out a treatment. That could be a screenplay. That could be a sizzle reel. Whatever it is, once it's fixed in a way that can be reproduced, that's when copyright attaches. And that's an important point. I don't want you to be thinking about copyright or other forms of intellectual property like trademark as verbs. A lot of people say things like, did you copyright that? Did you trademark that? And that's not how I want you to be thinking about it conceptually, because when you think about it that way, the implication is that you have to go to the government and make some sort of application to get your rights from the government. And that's not how the law works. Copyright springs into existence automatically upon the creation of an original work that's fixed in a tangible form. So when you finish your screenplay, you own the copyright then, automatically. Now, there are advantages to registering it with the government and the Copyright Office that we'll talk about, but I want you to understand you are the copyright owner whether you register your work with the government or not. What doesn't copyright apply to? I just mentioned ideas. It doesn't apply to ideas. It doesn't apply to processes, systems, things like that. It doesn't apply to mechanical or utilitarian items. And later we'll do a little bit of I'll give you a little bit of a distinction between patent and copyright, but it doesn't apply to those things. For our purposes, if you're here and you're working in film in any of a variety of ways, you're probably participating in the creation of copyrighted works. And then the question becomes, who owns them? Those advantages of registration are important though. And so the government really incentivizes you. They want you to file your copyrights with the government. They're going to give you benefits if you do so. And luckily the film and TV industry is really good at this. You know, I do a lot of chain of title work on old properties, And you can track movie studios and networks and production companies' copyrights going back decades and decades and decades and decades, because the film and TV industry is very careful about recording assignments or licenses or film options or book to film options and keeping track of where they go. It can be messy, and you have to know how to do it, but other industries don't do it like the film industry does. They take full advantage of it. The advantages to registration are really simple. You're presumed to be the owner of the copyright if the Copyright Office issues you a registration. That's a legal presumption. That means when you go into court, the judge is going to look at you, you're going to hold up your certificate of copyright registration, and they're going to say, that's the copyright owner. And then you're not fighting about who created the work. So that's important. Even more important, though, you can't even get in the courthouse doors without that piece of paper, which is a really fundamentally important thing. If you're a copyright owner, and I'm going to back up, I told you, don't worry about registering with the government because copyright springs into existence automatically. Well, now that's true, but now you do have to worry about the government because you can't enforce your rights in your copyright without that registration issued by them. And so that makes the information required to go into the copyright registration application very important. So the year you created the work, whether you've published the work, and what that means is whether you've distributed copies to other people for commercial purposes, like redistribution. Those things become vitally important when being able to register the work. Also knowing who owns the copyright, if it's one owner or joint owners, being able to actually clearly delineate that in the application becomes important, because you don't want to have a faulty or defective registration. And the Copyright Office isn't going to help you. They're going to assume everything you put in the application is true, and they're just going to accept it. So make sure if you are registering your copyright, you take a class like this, or that you research it, or that you talk to someone like me or Brian, because it becomes pretty important. One last thing I want to talk about copyright before I hand it back to Brian is this. Copyright isn't one thing. Copyright is actually a bundle of rights. And when I'm giving these kinds of lectures, I tell people the easiest way to think about it is think about it like a pizza or a pie. And that's going to seem silly at first, but bear with me because it kind of works. This bundle of rights are different things that the government says the copyright owner is the only person allowed to do. So let's use a screenplay. Actually, let's use a book. Someone writes a book and they have a manuscript and they want to get it published, and they go to Simon & Schuster and they do a publishing deal. Well, they have a bundle of rights here, and they're going to take a slice of that pizza and they're going to give it to Simon & Schuster. They're going to give them North American hardcover English, but they may give a Spanish publisher Spanish rights. They may give an audio publisher, a different someone, audio rights. And these are all little pieces of the pizza that you can hand out. What those pieces are, and I'll walk through them with you right now, are really important. The most important one is really obvious too. Copyright. It's the right to make a copy. So if you're the copyright owner of a work, you're the only person allowed to reproduce it, to make a copy of it. You know, this whole idea that was rampant in music, when digital distribution came around, it really changed a lot of industries, music first of all. And this idea of sharing came into existence, and people started thinking, well, if I can access something online, it must be legal to take it because it's so easy to get. And that's just contrary to the law. The technology often outstrips the law, and so it makes it really easy for us to get access to things that we may not have the legal right to use. But if a copyright owner is the only person who has the right to use it, then this idea of sharing doesn't really exist in the law. And so if you find things online, you need to be very careful about what you do with them. And we're going to talk more about rights clearances and such, but I just want to warn you that a really smart way to approach stuff you find online is to assume it's under copyright until you know otherwise. because that can be real problematic. So the right to make a copy is the first important right in that bundle of rights. This next one is very important too. It's the right to prepare a derivative work. This is another exclusive right the copyright owner holds. The right to prepare a derivative work based upon a work is really important. And I'll give you the easiest example. You write a book, you sell the North American hardcover to Simon & Schuster, and it's a bestseller. And then, you know, Lionsgate says, hey, we really want to option that book and make a film. Well, when you give them the option, you're giving them a little piece of pizza. Let's say they find a director and a screenwriter and they get financing and they actually write a screenplay. That screenplay is a derivative work based upon the book. So it's not the same copyright that's in the book, but it derives from it. And so you authorize someone to create it. Well, the copyright owner is the only person who can authorize people to create derivative works. All right, other important rights in that bundle are the right to distribute copies. So it's not just the right to make a copy, but it's the right to distribute, sell, commercially exploit those copies in commerce. And, you know, this is the United States. We're a serious capitalist system. We all know that. So remember, copyright law is a very commercial law in the sense that when Congress drafted these statutes, they were looking at where in commerce does this all fit in this sort of information economy. And frequently with copyrighted works, it involves the reproduction of the work. So every record that was ever pressed on vinyl, every cassette tape, every DVD, every Blu-ray disc. Now streaming has really changed this because streaming, and this is being addressed in case law right now, but streaming, new copies aren't actually made. And so it's sort of a new facet of copyright law that's pretty interesting. In that bundle, there are some other smaller things, you know, with sound recordings, it's the right to perform the work publicly. With literary music, dramatic, choreographic works, it's the right to perform or display a pictograph or visual work. But I want you to think about copyright as a bundle of rights. It's the right to copy. It's the right to distribute and sell copies. It's the right to make derivative works. It's the right to display. And what display is basically is just showing something. So, you know, when you show a movie on a screen, that's display. All right, I'm going to hand off to Brian because I think that covers a lot. I can do some more on copyright later, but I'm monopolizing the talk. He didn't jump in with any points, but I'm sure he'll make them now. Brian, do you want to take over with contracts, licenses, that kind of thing?
Yeah, before I do that, one thing we always like to know is who we're talking with. So we're going to play a game called Two Sentences, right? And that means that you have 2 sentences to talk about who you are and what you do creatively. And these should be like normal English sentences, not world record. I'm going to get 1,000 words into a one free-form sentence. And so I'm going to call on you. And what we can do right now is I want everyone who has the ability to show their video, and you don't have to be on video this entire talk, but everyone who's on this phone call who can activate their video so we can see your beautiful faces and handsome faces, please activate your videos now. And I'm going to call on each one of you, and you're going to get a chance to tell everyone else on the phone or on the Zoom call who you are and what you do creatively in 2 sentences. All right. And you do have the ability to unmute yourself when it's your turn to talk and then to remute yourself when you're done. So, and I hope I'm getting the name right. So we're going to start with Jabril Thomas. So
yes, you pronounced it correctly. I'm shocked. Hi, everybody. My name is Jabril. I'm a recent law graduate. I graduated in May. And my goal is to be like you guys and help represent creatives. So I'm taking the time to look at some workshops that'll help me get a lay of the land.
Excellent. Thank you, Jabril. And we look forward, if you haven't yet joined WALA as a volunteer, we look forward to having you join WALA as a volunteer. Best way to create good friendships and a career is by getting in the field you want. And whether it's volunteering or anything else, surround yourself with the people who you want to be your peers. All right. Next, we're going to go to Nika.
Hello, thanks so much for the talk. I'm an independent animator, filmmaker, specialized in animation from UK. I'm also a teacher, but mainly do my own work. So I'm kind of here from the artist's point of view. So I actually have quite a few questions, but you might not be able to answer it because UK law is different from American law, which I'm realizing. But maybe we'll see.
It's pretty close.
Okay, good.
Very simple.
Cool, thanks.
Welcome.
Great, Nika. All right, Stephen or Stefan, are you able to join?
I'm not able to join by visual, but I'm certainly here with voice right now. So
Excellent. Well, tell us who you are and what you do creatively, please.
I am a photographer, jewelry designer, and also recently sort of creating online educational content, which of course is a different area, but I think it's creative. So I have some questions about that too, as to where I would go for information. It seems like the universities, if you offer a course online, they own the IP and the hell with you. Anyways.
Excellent. Well, great to have you here. We're going to continue. Josh Leong.
Hello, I am Josh. I am a student over at NYU, but I do have a film in this year's festival. I'm a director, and I'm here along with my producer, Sophia, here, who is able to speak right now. But we are kind of in the process of figuring out, developing our short into our first feature, just understanding some legal aspects that we can have set up at the beginning of the process to make sure things move smoothly. And just also very interested in legal aspects of how to exploit a film after it's made and what needs to be set up, from the beginning to make sure everything goes smoothly.
Welcome.
All right, next we're going to go to Bonnie. And unmute.
Thank you. Okay. I'm a footage and stills researcher, and I work primarily at the National Archives and the Library of Congress.
Oh, great.
So I'm always in legal things.
Welcome, Bonnie.
All right, now we're going to go to Paul Marengo.
Hey guys, I'm just here to listen in and take everything in.
Welcome, Paul.
Welcome, Paul.
How are you, buddy?
All right, now let's see. Jamila.
Hi, yes, that's right, Jamila. Nice to see you all. I am a structural engineer and I am a STEM content creator and burgeoning filmmaker. So all of this legal information is very useful for me, and I think it will be in the future. So thank you all for doing this.
Welcome.
Welcome. All right, Sophia. Sophia Barra. Okay, we'll
Oh, Sophia says her mic isn't working. Okay, no problem, right. Sophia.
No problem. Cash.
Hey guys, hey, I'm Kash. I'm an actor, an improviser. I also do photography, but I have a full-time job. I'm a management consultant.
Cool. Welcome.
Great to have you.
Thank you.
And Peter, I don't know if we heard you talk about what you do creatively, so maybe just jump back on and tell us if you have any creative passions.
There I am. Well, I do a bit of writing. In fact, I've taken screenwriting coursework in the past. When after college, I went back to NYU night school and took some writing courses. So I do love reading and writing and everything about filmmaking, and knowledge about copyright law and other types of law is critical to know. So thank you for being here and helping us all understand this better.
Excellent. All right. Thank you, Peter. All right. So is there anybody who has not yet introduced themselves? I want to make sure we include everyone before we move on. All right. So I think everyone has now introduced themselves. Great. So let me say a couple macro level things here. What is entertainment law? And entertainment law really is where we're trying to take all these different facets of law, which could be contracts, it could be litigation, it could be intellectual property, all these different things that exist separate and apart from this concept of entertainment, and we blend them all together and we say entertainment law is this type of law that touches on all these various different things, and we bring them together in this one concept of entertainment law. But there is no such thing as a formal entertainment law, right? Like there's no entertainment law judge. There's no entertainment law like set of laws in the construct of government, in the construct of law that's this is entertainment law. That's not how it works. So an entertainment lawyer is a person who looks out into the world and they try to find this wide variety of laws, and then they try to apply them to the needs of somebody who produces content, who creates content, who distributes content in this concept of entertainment. So that's the macro level. Now, John talked a lot about copyrights. And that's one of the 800-pound gorillas in this concept of entertainment and entertainment law. The other huge concept is contracts. And the reason that intellectual property is important is because that is the basis, that is what you own that lets you then have a career. If you don't own intellectual property, if you don't have a license to it, if it's not controlled in some way, then in a capitalistic system, it's hard to monetize that. And so when we talk about the creators are the economic engines of our system, right? If you have all these industries in the world, the people who write the literary works, who make the movies, the people who design the buildings, the people who invent things, they, at the very basis of it, they're like that seed which creates value throughout the entire rest of the economy. And when you come to me, when you go to John, we're trying to keep the person who creates this property, we're trying to keep them connected to it so that they're able to monetize it, and they're able, in this real world system, they're able to pay their bills. And so there used to be predatory practices where the person who would create something was, taken apart from it, and they wouldn't keep what they owned, or they wouldn't monetize from it. And so you would have an amazing work that would go on to make millions, hundreds of millions of dollars, and you have the creator who, is starving. And, when John and I look at this, it breaks our heart. And we've said that our career focus is we want to help the creatives. We want to help the person who is creating this idea that becomes part of the engine of our economy. And we want to make sure that they're able to pay their rent. They're able to feed their kids. They're able to have these real world needs met that stem from the amazing value that they create. And so when we talk about this, the concept of ownership, of protecting a right, and then the concept of monetizing it, that is unified with what we call a contract. And the contract is an agreement. And before I start getting into all the construct of what a contract is, I want to talk about, as a filmmaker, as a creative, what that looks like. What does a contract look like? What is an example? So a distribution agreement, that is a contract. A license agreement, that is a contract. An independent contractor agreement, that is a contract. Also related to that is a work for hire agreement. So that is a contract. A waiver or release, a lease or rental agreement, a services agreement. These are all contracts. Now they appear at different points in time of your creative production, but they're all contracts. And so you need to work with a lawyer to make sure that you get all these contracts when they're supposed to be executed, when they're supposed to be effected, so that at the end, when you go to a distribution company and you get distribution, you own the property that you want to distribute. So let me talk about some of these contracts. A distribution agreement. That is where you have intellectual property rights to something. You bring it to an entity, a company, and they distribute it on your behalf. They put investment into publicizing it, into repackaging it, into finishing it, into doing all these things that make it more marketable. And then they market it. And then the people out there will pay maybe or buy to see it. And then you get money, you participate in that distribution, and it stems from a distribution agreement. Now, a license agreement is similar to that. It's basically where you have this creative property and you're giving it to somebody for a certain amount of time, and you're either getting money or commission or a combination of those things. And when I speak with you, I'm trying not to talk with you in, as though if I was talking lawyer to lawyer, I'd probably be having a different conversation in terms of how I describe all these things, but I'm really trying to make the words that I use track more with your day-to-day words and the words that you have as a creative professional. All right, now an independent contractor agreement. And we're also gonna roll work for hire into this. So what that agreement is it basically is, I have a vision. I want to own intellectual property. I want to bring somebody else in to collaborate with me, but I want to be really clear. They are not a co-author with me. I am the creative engine here. I'm bringing them in. I'm compensating them for their work with me, but I want to make sure that I am the owner, and I want to make sure that they're not considered my employee. They're not considered my agent. I want to really specify their role in this. And so I would do that with an independent contractor agreement. I would say, we're not partners. You're not my employee. You're not my agent. That is an independent contractor agreement. And it has really important measures when it comes to the rights related to employment law. And so again, you want to make sure to speak with a lawyer about making sure that if you hire an independent contractor, that they actually are your independent contractor legally. If you're in California, there's a whole nother set of things you need to look at. So you would want to speak to a California specific lawyer for independent contractor work in California. Now, work for hire often will be included in an independent contractor agreement. Sometimes it'll be separate. Work for hire basically says, I am the creative person here. It is my creative work. I maintain creative ownership. And yes, I'm having you work on this, but it's not your work of authorship. And so when it comes time for somebody to reap the profits from a creative work, even though a different person worked with me on it, that different person is agreeing in this work for hire under the United States copyright law that they're not my co-author. Absent this work for hire agreement, you run the risk of people that you bring in to collaborate with you, even if you pay them, even if you have a verbal agreement, if they don't sign off on a work for hire, you run a big risk that they could come back later and claim that they're your co-author. And that has problems with distribution. Yes, John.
Can I give a real world example just from film? So this is really important. And I'm only going to ever interrupt Brian if I feel like there's a big point to make. So you're an independent filmmaker. You bring someone in to work the camera. He's your friend. You do a handshake. You pay him at the end of the day. He takes X number of hours of film, video, whatever. He gives it to you. You both agree it's yours. He tells you you own it. You own the copyright. He's like, I don't want anything. You gave me my $500. You don't own it if you don't have the agreement Brian is describing, because what you've done is you've hired him as a contractor, but you haven't put it in writing, and you don't have the work made for hire provision in it that makes the copyright yours and not his. And so at the end of the day, he still owns it. And Brian and I have seen this a million times where people are at the end of a production trying to figure out, well, I use 5 different people on the camera. Do I have to get a new contract with each of them? It's a lot more difficult to go back and try and put the pieces all together afterwards than during. And that's what Brian highlighted for you at the beginning. Putting these things in place in advance is important. Luckily, the TV and film industry is really good about work for hire at the network and larger level. They just hand them out. It's very pro forma, perfunctory. It happens throughout the industry. It's on smaller independent projects or people just starting out that you need to be aware of these issues. Sorry, Brian.
Yep. While we're on the point of having a more interactive conversation, Nika, I'd like you to unmute your mic and show your face. And why don't you ask your question and we can talk it through.
Hello, sure. So just to the point of what you were talking about. So how does this work in a situation where the person who you've hired to work for you is creating a new content, which is coming from them, obviously, and does the right to that work is remaining under him or not?
So the lawyer answer is it depends, right? So
as always.
Yeah. So it really depends. And so let's say that Nika, you come up with the characters, right? Mm-hmm. And so the core creativity of it comes from you. Then there's a lot stronger argument that you're hiring somebody to flush it out, right? I would really say this probably goes back to contracts. And if you're having somebody do a work for hire agreement, if I was your lawyer, at the core of it, I would say, if there's an agreement and they're signing to it, where you could say, I want you to make me a movie about superheroes. Mm-hmm. And they go, great, I'll make you a movie about superheroes. If they're signing a work for hire agreement that says, I am an independent contractor and I'm working for Nika, and Nika owns all my creative output for this project,
yeah,
then I would argue, if I was your lawyer, I would say that that's good enough and that you own it. And John, do you want to add in there?
Yeah, I want to jump in on it because Nika, you're from the UK, right?
Yep.
Okay. UK law doesn't recognize work for hire the way that US law does. So what we're telling you, I'm putting a caveat next to it for you. Mm-hmm. But generally speaking, what Brian just said is correct. I'm going to give you something that's going to help you conceptualize work for hire in the US copyright law. There's 2 kinds of work for hire. There's corporate copyright. In US law, an employee of an employer, and this is important, an employee who gets a W-2, not a contractor, a real employee on a salary who gets a W-2 and maybe benefits, that person's work product is, in the course of the business, is always owned by the employer. Yeah. And the easy way to think about it is think about Disney, right? Yeah. Disney has like 60 animators who sit there and they go, all right, brainstorm the next princess. Everything those animators make. Yeah.
I think it's the same in UK.
Yeah, whether it's chosen or not, that's owned by Disney. The problem we're talking about here, that corporate copyright's really clear. We're talking about making an independent contractor who isn't your employer, making their work as if they were your employee. So the contractor comes in, because most production companies have like 3 employees and then they hire like 60 crew and creative people and they make a movie. Those people all sign independent contracts that have this work made for hire language such that anything they create, anything under the contract is owned by the person they sign the contract with. In the film industry, that would be the producer generally. They're trying to centralize ownership with the producer, the production company.
Yeah.
So in the UK, I don't believe your contract's going to look exactly like ours. It may not have language like work for hire, but it's going to accomplish the same result.
Yeah, yeah.
In the US, you can't do this orally. You can't do this just by email. You can't do it on a handshake.
Excellent. Nika, thank you. Thank you. All right. And so one thing that John and I do when we write these work for hire agreements is we do them as if then, right? So we don't give one level of protection. Or like, by default, this is a work for hire. If it's not a work for hire, then it's this. If it's not this, it's this. And so there's like 10, as we'll get as many bites at the apple for our client as possible, so that they're able to retain ownership of their creative expression as intended by the parties. Now, I want to go back to something that John alluded to. He talked about an employee relationship. Now, if somebody is an employee of an employer, the risk that happens with this is not only does the employer own everything that's made by that employee during the scope of their 9 to 5, that employee will sometimes risk all of their creative production during the term of their employment. And so that's why you have to read these employment contracts really carefully. So if there's a computer engineer who's animating a movie, there is a risk in his or her own part-time, there's a risk that that engineer's employer might end up being the owner of the IP for the owner of that intellectual property. And so you really need to review these agreements carefully if you're an employee. Another thing that I want to mention is when it comes to crew agreements. So crew agreements are often independent contractor agreements. You want to have your crew agreement and your cast agreement if you're an independent filmmaker. You want to have them with overlapping provisions. A lot of times your gaffer is going to end up being an extra. And a lot of times your extra might end up being your gaffer, and they might end up being like your story consultant or your editor. So the line between cast and crew, when we get,
it all might be you.
yeah. And if it is all you and you have a production company, you still need to sign your releases, crazy enough, to your production company so that, you know, it's able to license and distribute the work that has you in it. Okay, so, but just to repeat that last part, you want your agreement with your cast and crew to have overlapping releases so you can use cast as crew and use crew as cast. Do it all in one agreement. All right. And then that talks about waivers and releases. So, or brings us into that. So waivers and releases, basically, it says you can work with me, you're not going to sue me. It says I can film you and I'm allowed to use your image in this creative production as we agree to. And then there's also, so that's a simple explanation of waivers and releases. It can get a lot more in depth. We could start talking about location. We can start talking about other things. And Cash, I see you wrote something about, does an NDA fall under contracts? And so it does. An NDA does fall under contracts, and it brings in intellectual property specifically. And it really says that I'm going to talk to somebody about working with them. In the entertainment world, this is where it comes up. I'm going to talk with somebody about working with them or about giving them an investment opportunity. And because this intellectual property is still developing and I don't want it to get out, and I want to keep this stuff secret, and I don't want somebody possibly to compete with me on this, I would have them sign an agreement. Most heavy hitters are not going to sign that thing, because in entertainment, there really are not that many new ideas. It really is the execution of an idea or the licensing of intellectual property or the ownership of intellectual property that gives value to it.
And just to be clear, NDA means non-disclosure agreement. And what Brian's talking about is when you're submitting to people or they're submitting to you and you're saying, I'm going to give you my treatment or my screenplay, but I want you to keep it confidential. It may also involve a non-competition clause that says you can't exploit it, things like that.
Yep. Excellent. And then of these important contracts, another would be a services agreement, right? And a services agreement is not always the same as an independent contractor agreement. uh, the relationship of being independent contractors is the same, but the services might be where I'm just hiring somebody to do one specific thing, and they're not necessarily part of my crew or my cast. And that could be like, it could be something like an accountant, you know, that when I talk about services, that's where I speak about a services agreement. John, what do you want to add in there?
A lawyer.
Oh, lawyer, yeah, an accountant, a lawyer. If you could go to somebody and they have like their own menu of services that they provide, and they're not like coming in, if someone shows up on your set and they're your DP and you guys have an understanding of what a DP does, but at the end of the day, they're going to do everything that needs to happen to make the film finish. Well, that's independent contractor under, as I'm explaining it. Services agreement is, if I'm your lawyer, I'm probably not going to also be a gaffer, right? And you come to me, I'm going to give you a menu of services that I offer. And these are the things that fall into our relationship. And so that is my intent when I talk about a services agreement. And generally, when someone works with me, I'm giving them my services agreement and they're signing it. The other way around is if someone's a producer, they're having their lawyer come up with an independent contractor agreement, and you know, she as the producer will be giving her agreement to everybody. And the thing I want to make really clear, and this is one of the huge takeaways you need to understand. If you're the creative professional, you need to invest the time, energy, and resources to come up with your own agreements. Do not let your people who come to work with you give you their agreement that you sign, because that is going to be a Pandora's box. We have a client who is a producer, and that producer signed somebody else's agreement and is just now, after years of frustration, resolving this with so much more cost than is needed because that producer didn't understand and was so busy with everything else that they just took the simplest immediate action, which was accept somebody else's agreement. The real power of contracts is you being the person who dictates the terms in them. And so let's now talk about contracts, macro level, what they are. Before I go into that, John, did you want to add anything?
On contracts? No, I was going to talk about when I get back to copyright, when you're ready, I'm going to talk about some specific, a little bit more about licenses, things like that.
All right.
Content, but I have more to do on copyright, obviously.
All right. Excellent. All right. So everybody, let's talk about contracts. And again, this is person-to-person communication. It's not if I'm teaching a room full of lawyers or law students. So contracts, they're an agreement by two or more people entered into voluntarily with the intent to be bound, right? And so examples are non-disclosure agreement, terms of use, lease, services agreement, distribution agreement, a sale of goods contract. And there's three parts to a contract. There is an offer, there is an acceptance, and there is consideration. Will you wash my car? Yes, I will wash your car for $100. Great, here's $100. We have an offer, will you wash my car? We have acceptance, and I guess the offer really should be, I would like you to wash my car for $100, right? And that's the offer. The acceptance is yes. The consideration is the $100. All right. Perfect. So something is given, something is gotten, something is received as compensation. All right. So now there's some requirements to what a contract needs to look like. We're not going to go into every one of them, but the big picture stuff, it has to be legal, right? If we get into a contract for, drug dealing, if somebody does a contract for like murder for hire or some horrible thing like that, you can't enforce that contract regardless of what happened. And then there also needs to be capacity, right, to contract. When we talk about capacity, it means somebody has to be like, have their mind about them. They have to be often of legal age, but sometimes, you know, in the digital economy, sometimes somebody who's underage with parental consent, you know, can start their business and become a gajillionaire before they turn 18. And then there also needs to be no force or duress in making someone sign a contract. There needs to be like no material lies or misrepresentations, no blackmail. So those are, I guess, some of the core requirements. Now, generally, a contract or an agreement can actually be written or spoken. And so not all agreements need to be in writing. Now, as a lawyer, I tell my clients, get it in writing, get it in writing, get it in writing. But that doesn't always have to be the case. That said, there are some examples that it really does need to be the case. And we talked a lot about work for hire agreements. That's a great example. A work for hire agreement needs to be in writing. I'll say that again. A work for hire agreement needs to be in writing. So you want to make sure that you have that. And, you know, you could talk about like the sale of non-custom goods, you know, one person answering the debt for another, a deal that has something to do with land. Those are some other examples of contracts that must be in writing. So excellent. All right. So John, it is back to you, my friend.
I wanted to add one thing on the contract because Brian laid out the elements of making the contract well. There's another important thing about contracts, though. Once you have that mutual meeting of the minds, right? $100, wash the car. There's something in the contract Brian mentioned called consideration. Those are the things of value flowing each way. In that case, it's $100. That's obviously valuable. And it's the labor of washing the car that flows the other way. Whether or not those things actually flow to the other party, though, that consideration is important, and that's called performance. If one side performs and the other doesn't, then that party that doesn't perform is in breach. So not only do both people have to make the promises, there has to be valuable consideration on each side, they then have to perform. By the way, what if there's not valuable consideration on one side? What if I say, you know, you're going to wash my car for free, and you agree and you wash my car? Was that a contract for something of value? No, that was a gift. So if you're giving something of value and not getting anything in return, it's not a contract for anything of value because there's not consideration on both sides. I'm going to segue.
But as a lawyer, somebody could then say, well, I depended on that agreement and I acted and performed based on the promise of that gift. And so while that might not have been a contract on its own, once I started performing and depending on your promise, it now legally binds you to that promise, sir.
Maybe. I'm going to segue into, I'm going to take what Brian mentioned with the work for hire agreements need to be in writing. With copyright law and with different areas of law, there are certain formalities that have to be adhered to for legal things to take place. You know, if I walk up to you on the sidewalk outside your house and I tell you I'm going to give you a suitcase full of cash if you give me your keys and let me have your house, and we make the exchange, did I buy your house? No. I mean, I might have rented it or, you know, got some informal right to live it, to abide in it, but I don't technically own it because in our legal system, if you don't sign title and deeds and do certain formalities in writing, signed by the right people, the thing didn't happen legally. So in copyright law, and this applies to the entertainment industry, but also other industries equally, if you don't do certain things in a writing signed by the right people, they don't happen. I'll give you an example. We mentioned work for hire. There's another scenario that's very important. It's called assignment of copyright. Frequently, things aren't work for hire, but that doesn't mean the party doing the creating can't transfer the copyright to the other party. one of the most common areas of this would be graphic design, right? You start your film company, you want a really cool logo to put in the credits, right? You know, and on your promotional materials. So you go to a graphic designer and you hire them and you love their work and they quote you a price, they give you some comps, you agree to the deal, and then you tell them, I need to own this though, I need this to be mine, and they say, sure, it'll be a full buyout. I'll even write that on the invoice. It'll say, you know, all rights, full buyout. It'll even say assignment of copyright. Assignment just means sale, by the way, or transfer, guys. And then they send you the invoice and they send you the work and you love the work and it becomes your logo and you send them a check and they cash the check. And everyone agrees that you own it. And now it's 20 years later and you're trying to sell your company and the investment banker lawyer is looking at your logo and he says, do you own that? And you say, yes. And he says, show me the paperwork. And you show it to him and there's no written document that where the graphic designer actually assigned you the rights, because an invoice isn't usually signed, it's just sent to you. That happens in graphic design all the time. I can't tell you how many CEOs I've had to go through that with, where decades later we're trying to track down a graphic designer who did their product packaging or characters for something. So an assignment or sale of a copyright has to be in writing, as well as work made for hire. Other things, an exclusive license. I'm going to talk to you a little bit about licensing. License, the word license is interchangeable with permission or authorization. And I want you to think about this. As a copyright owner, anytime you let anyone do anything with your work, you're giving them a license. You're giving them a permission. Those words are interchangeable. And then, you know, you may do it for nothing of value. You may do it for no money because you're going to get promotional value, right? And so you may let an influencer on Instagram do something with your work because you know it'll get eyeballs. There's a lot of reasons why people do these things. If you want your license to be an exclusive license, meaning this person's the only one who can do it, and think about distribution of a film, right? You know, a premium, Netflix is going to want an exclusive. A theater chain is going to want an exclusive. They're not going to want to compete with other people for your work. Any exclusive grant of rights for a copyrighted work has to be in writing. So let's go back to my book scenario. When you do that deal with Simon & Schuster, that's an exclusive publishing deal. When you do that option with Lionsgate, that's an exclusive option. They're the only ones who get to develop it. They're the only ones who get to try to find a screenwriter. If they execute the option and they hire the screenwriter and they pay you what they're going to pay you, then they have the exclusive right to make the film. And so exclusive licenses, grants of rights have to be in writing too. There's some other important parts of copyright that you got to remember, and these have to be in writing as well, but I'm going to get a little deeper into them. By the way, the flip side of an exclusive license being in writing, has to be in writing, is that a non-exclusive license doesn't have to be in writing. And so you can do handshake deals or oral deals or email deals where you say, yeah, you can take that still from my film and put it on posters. Go ahead. I just want $5 a poster. You can do that by email, but then you can do it to their competitor because it's a non-exclusive license. In film and some other industries, there's a lot of collaboration, and this becomes important because 3 people, for example, may work on a screenplay. Copyright law, the law is black and white. Creativity is not black and white, right? It's amorphous, it's ambiguous. But the law is trying to set hard, fast rules. It's difficult to do that. It's difficult for the law to get its arms around creativity, but it's trying. And I'm going to give you this example of how it treats collaboration in the form of joint works of authorship. Under US copyright law, if 2 or more people collaborate on any work, and what that means is that they each provide original authorship with the intent that the finished whole is a unified whole, then absent a writing otherwise, they're all considered equal joint copyright owners. Why is that problematic? Well, let's say I write a great 110-page screenplay, 3 acts, narrative arc, everything's great, but I don't do my endings well, or I don't do dialogue well. And I bring in someone to add new material, new original writing to my screenplay, but only 10%. 90% of it's still my original work. And it's my old friend from college. And I say, you're the best at dialogue. Come in, punch up my dialogue. You know, you're not going to get a writer's credit on this, but I'll pay you X. And they do it and you pay them. Now they own, if you don't have a writing, 50% of your screenplay, copyright. Worse than that, though, absent a joint authorship agreement that dictates control and how people can exploit the work, every joint author of a collaboration or jointly owned copyrighted work can separately exploit it without the permission of the other. So your old college roommate, who isn't as close to you as you thought he was, writes 10% of it. Now he's a half owner of it because you don't have anything in writing signed by both of you. He can go do a deal with Lionsgate behind your back and doesn't even have to get your permission or tell you. So then he does the deal, and then he's only required under the law to report back to you net, not gross, net profits. So joint authorship agreements become vitally important, and they must be in writing, signed by all parties to be enforceable. And so I'm trying to give you some scary examples of when that's the case.
Hey, John. I just want to mention that it's about 3 o'clock now.
Yeah.
And I know from our conversations, you could end up speaking for 5 hours about this, and it's great and it's interesting. I just want to chime in that I want to make sure we leave enough time to answer questions about copyright and contracts and all this.
Let me do 3 minutes on fair use, and I see we have some questions. Actually, let's look at the questions. What actually makes a contract as a written agreement a legal document? Is there a particular template? Not necessarily. A written contract is where two parties agree to something. Brian broke down the elements. You need an offer and an acceptance. You need things of value, consideration, and then ultimately you will need performance to see if it was effectuated. But it can be as simple as a couple sentences. Wash my car for $100? Yes, signed. That's a contract. So does it need to be a particular template? It's got to have the barest of those elements contained within it.
And what you will find lots of commonalities, you know, where it'll start off with the recitals, whereas and what's forth and hence thereto, the parties agree as follows, and then it'll list it in, and then it says we'll be mutually bound and we'll go to their successors. So there are common templates that we use. A lot of those are just as have evolved because that's how we understand them. That's the language we talk of contracts. And we want to have some uniformity so that if I go to a judge and I need to enforce it, the judge looks at the contract we used and the judge looks at contracts that she's interpreted for the past 10 years based on contracts that go back for 500 years. And it looks enough like the other things that everybody understands what we're talking about. It's possible that somebody could write a new form of contract as a Venn diagram with poetic prose and all this other stuff with signatures that meets the legal definition of a contract. I wouldn't advise it. And so I would say trying to stick with the normal form.
Jamila wrote, by posting content to YouTube, it seems you're agreeing to grant a license for them to create derivative works. What are your thoughts on posting original content to YouTube? I haven't looked at the YouTube standard click-through agreements lately. In the past, I have, obviously. To the extent you're giving them the right to create a derivative, I think it only has to do with cropping and framing in their platform. I don't think that you're giving them the right, if you upload a 20-minute original video, for them to edit it down to 3 minutes and use it in a commercial. I don't think that's the case. If you recall, all these social media companies, YouTube, Facebook, they always get big scares periodically because everyone says, oh, they're changing their terms of service to allow them to use your uploaded content in their own advertising or promotional stuff. And they always back off if they are considering those changes. So generally, I don't think they're allowed to do that. Does that answer your question, Jamila?
Well, yes, but there's this particular part that just says, by providing content to the service, you grant to YouTube a worldwide, non-exclusive, royalty-free, sub-licensable, and transferable license to use that content, including to reproduce, distribute, prepare derivative works,
Yep.
display, and perform it, yada, yada. So it always made me
I think if you read the whole thing, it has limitations on what they're allowed to do with those derivative works. Again, I think the derivatives they're creating allow the work to be displayed in their platform. I don't think they're allowed to take a still from your video and make a t-shirt out of it, for example, which would be a derivative work.
Okay, thank you.
Brian, any thoughts?
This agreement, you know, they have an army of lawyers, and this agreement is always being tweaked. So I would want to read what is currently in that agreement before I give specific advice. My guess, though, is that they are trying to push the limits as far as they can go to get as much rights as they can get to prevent lawsuit. And so, you know, they might be wanting, they might be putting things in there that let them come up with what might be considered a derivative work, not that they plan to take someone's work and actually produce it further without that party involved. But YouTube doesn't want to be sued. And so they're going to try and squeeze everything under the sun in there. And separate and apart from YouTube, by you posting stuff on YouTube, you just need to understand that it's out there. It's amazing it's out there, but it's also a risk that it's out there. By you posting on YouTube, the users, the viewers generally are not going to be getting rights to take your work and then change it and use it on their own, unless they have an affirmative defense. And so when somebody takes your work and they either re-show part of it or they change it and use it in their own way, they may be subject to copyright infringement, or they may have an affirmative defense that lets them say, wait a minute, I can do this because I'm protected by something called fair use. John?
All right, let's do it. So fair use is important in copyright because technically, I gave you the bundle of rights that's the pizza, right? And the government has given the copyright owner the exclusive ability to do those things. Fair use is important because it's that time when you get to do what the copyright owner is normally allowed to do, and you don't get in trouble for it. You're not liable for it, to use the legal terminology. And specifically, you're not liable for copyright infringement. And so, you know, if I take a still from your film and I love that image and I put it on t-shirts and I sell 1 million t-shirts, that's copyright infringement. If it's determined that such a use is a fair use, then yes, it may be copyright infringement, but I'm not liable to you for anything in terms of damages. And I'm going to tell you sort of what fair use is. Fair use is a statutorily created area of law that allows for the use of someone else's copyrighted work in your work or in some fashion, and you're not going to be liable. The use you make of it has to fall within certain categories like criticism, commentary, news reporting, and I don't mean any news reporting, pretty much hot news reporting, and I can give you some examples of that. Teaching and educational use, right? That's logical. People should be able to put a painting up on a whiteboard so that the people in a painting class can see it. Scholarship and research has fair use exceptions. So if you fall within one of those categories, your use might be a fair use, but not every one of those uses in those categories is a fair use. You have to look at 4 main elements to determine whether it's a fair use. The first one is you look at the purpose and the character of the use. Whether the use is commercial, for example, versus nonprofit. And then you look at the nature of the copyrighted works, and you look at whether or not the second users use was transformative. I'll give you an example. In 2008, when Obama ran for president, there was a Getty or Reuters, I can't remember which, it was an AP photo. There was an old photo of him. There was a nice photo, but no one, it was just a stock news photo of him that they licensed. Shepard Fairey, a famous guerrilla artist who often flirts with the gray lines of copyright use, took that photo. He ran it through, I think, InDesign, not Photoshop, and he created a work of art that became the Hope poster, the Obama iconic Hope image. AP wrote him a letter, real nice letter, and said, hey, it looks like you've infringed our copyright. Why don't you have your lawyers get in touch with us and we'll work it out. He sued them for threatening him with copyright infringement because he wanted to test the boundaries of fair use, and he wanted to claim that his poster was a transformative political speech use, very different than a typical AP news photo use. So the nature of the work became important because he said it was very different. I think he's wrong. I think a photograph run through a Photoshop type program is still just a two-dimensional visual work of art, and he didn't really transform it much. You then have to look, the third element is you look at the substantiality or portion of the work used. So if you're a documentary, and I used to deal with this a lot because of some of the properties I've represented. My old partner and I represented the Zapruder film of John Kennedy being assassinated for many years. And everyone wanted to use 1 or 2 or 3 frames from that. And you guys can guess which ones. They didn't care about when they were coming under the bridge, but they did care about the assassination itself. And they would always use them in their books or their documentaries or their different things, and they would claim fair use. And we would always come back to them and say, no. And the reason they claimed fair use is they said, well, 1 frame of a thousands and thousands and thousands of frame film is a de minimis, non-substantial portion of the work. And we would say, no, it's the core of the work, because that's the essence of this film, is that moment when he's assassinated. The last element of fair use to think about, and this goes back to whether it's a commercial use, is the effect on the marketplace for the original work. This is all important for you guys making films, because you have to think about this when you're using pre-existing material, whether it's footage or music or anything else. You have to look at whether your use of it in your work is a fair use, or whether you need to get an authorization or license to use something. And frankly, our firm does analysis for filmmakers frequently. We just finished one for a documentary filmmaker, and we issue opinion letters like, yes, we think it's a fair use, or no, we don't. And then the filmmaker decides whether they're going to go get the license or not.
And so I just want to, for our filmmakers out there, if you're looking to get distribution, if you're looking to monetize, you need to start keeping a black book for your production. From black, where you fade in, to black, where you fade out. Every frame, every image, every sound, you need to be able to show that you own it, that you have rights to it, that it's public domain, or have a lawyer that says this is fair use. And so one of my clients is a distribution company for documentaries. And when somebody brings a documentary film to us, we are looking through black to black. We want to look at all their records, every name that appears in their credits, every still, everything there. We need to know that my client's not going to be opening a legal problem if they distribute a filmmaker's film. And I'm also going to make a quick comment about trademark, because we haven't talked about it, and I want you to understand what it is and why it's important in the context of a black book. So trademark.
Brian, Josh is asking you to repeat. Josh, what are you asking Brian to repeat?
The required kind of documents that would go into a documentary black book.
Okay, yeah. So fade in from black, fade out to black. In between there, if you're looking at your editing timeline, you're going to have your video, right? You're going to have your audio. You're going to have your titles. You're going to have your graphics. You're going to have all these things. if I go to a frame, any frame in your entire movie timeline, when I get to that frame, I should be able to identify what is the sound that I'm hearing. And for that sound, I need a release for every voice on that sound. If it's not a release, then I need a license agreement from where that sound was taken from. And if it's not a license agreement, then we need to be able to explain why it's fair use or public domain. And so these are the things that when John talks about clearance, this is what we work with clients to do. It's to make sure that everything in this film, all the content, is clear to use so that we can go and work with the distributor, so that we can go and put it out on a platform, so that we can get errors and omissions insurance. And so you need all this stuff documented. And so what that looks like, it's contracts. That's what you need, Josh. You need agreements. You need signed agreements. And these agreements are a work for hire agreement, a licensing agreement,
Releases.
a lease. And if it's not an agreement, then you need a letter from myself or John or someone else saying that we're using a clip of somebody else's movie, but we're making fun of their movie. They're not going to give us permission to it, but it's important to this work and to the comment that we're doing. This is satire or commentary or something. And if they sue us, it falls under the fair use defense, the affirmative defense of fair use. And if you have a lawyer who gives you this opinion letter, and this opinion letter is part of the package that you deliver to your distributor, and your distributor uses that to, go onto all these different platforms, that is the level of scrutiny that you need to be able to sustain and show.
And to be clear about this, guys, Brian mentioned his client who distributes. The distributor agreement is going to have, and all of them pretty much have, an ironclad paragraph called representations and warranties, where you are promising that you've done this. You're promising them repeatedly that you've cleared everything, that you have the rights to everything, or that you've evaluated it. And then if you're wrong, even if it's through ignorance, even if you think you've done it all right, but you're wrong, there's an indemnification section that's going to make sure that when they get sued by the person whose stuff you're using without permission, you have to defend them and pay their lawyers. So it's not just you who, like, I don't have any money. It doesn't matter if anyone sues me. The money's in the distributor. So they're going to get sued, and then you're going to have to defend them, or they're just going to sue you for indemnification under the contract. And you don't want to be in that situation at all. So doing all this on the front end is going to allow you to make those promises in the contract effectively.
And I see the follow-up is, what is errors and omissions insurance? And so that can be insurance carried by the filmmaker that says, I did everything here, but if there's an error, this protects that error. And then there might also be a whole nother level of errors and omissions insurance carried by the distributor, which says, the first line of protection is our filmmaker and our filmmaker's insurance company. But if for any reason that doesn't protect us, then we have this other insurance that will protect us. And this insurance will actually sue the filmmaker and the filmmaker's insurance company if they didn't do their jobs right. So there's many different layers of protection here, so that the distribution company, so that they can go to bed at night knowing that they're safe and they're protected. And the person standing on the front line saying, yes, my film is worthy of being distributed, you're not going to get sued over this. That's the filmmaker. That is her or his job. John.
Yeah, general commercial liability policies do not cover most things like content. So when Brian writes errors and omissions insurance, errors and omissions insurance is a specific specialty type of insurance that covers publishing, content distribution, creation, copyrighted works, filmmaking, those kinds of things.
Excellent. All right. So I just want to touch on trademark really quick. If I didn't yet, trademark, identifies the source of goods and services in the marketplace. Again, trademark identifies the source of goods and services in the marketplace. And so when you see a filmmaker or a TV show that has blurred out a logo, that's because they don't want Nike to sue them and to block distribution of their film, because the Nike logo appears on the shirt of somebody who's rolling a blunt or doing a murder for hire or doing some other thing that Nike tries really hard to keep separate and apart from their brand. And so the importance for filmmakers is manyfold, but two of them. Number one is you don't want to open up the bad element of trademark, which is somebody thinks that your work infringes or damages their mark and they go after you. The other element, though, is where filmmakers can monetize. They can monetize content. If I take a logo of, a product, if I'm doing something about organization, Marie Kodo, and if I inserted in this whole thing about organization, the logos of Ajax, the logos of Tide, if I inserted these logos, they might have a lot of value for those brands and they might be willing to pay me. And so when you watch American Idol or whatever these shows are, and they have like a cup of McDonald's coffee or Dunkin' Donuts coffee, and you see the brand position, they paid a lot of money for that, right? If you're watching a movie and you see them driving a Ford and there's a close-up on the Ford logo, Ford paid a lot of money for that. And so these are things that I want you to pay attention to, is logos generally should not appear in your film unless they are compensated. And you'll have some filmmakers who will create a whole bevy of trademarks that they use for products, right? And so every Tarantino film you watch, there's going to be certain brands of products you might not even notice, but they've invented these so that they don't get sued and he finds it funny.
Duff beer.
Yeah, exactly. Exactly. All right. So we've gone through a lot here. It's now 3:24. We have a couple minutes for any other questions, and then John and I will leave with closing words. So are there any questions that people have that we've not yet answered?
Sophia's saying goodbye. Bye, Sophia.
Bye, Sophia.
Thanks for coming.
All right. So we're gonna go to some closing comments. John, what do you got to say?
Think of this as the tip of the iceberg, guys. This is useful. We can't do a deep dive with you. What we're trying to do is give you an overlay and highlight some important points. But think of it as red flagging or issue spotting. Now you know these important points. The most important takeaway here for you is to get some familiarity with the legal aspects of your industry, of the creative industry you've chosen to be in, and then know when to reach out and ask for help from someone else who specializes in something. In this case, legal help. Be careful of just Googling, talent release online. When you find releases online, they often have disclaimers at the bottom of the page that say, always consult a lawyer. Well, I don't know if I want to be using a legal document that tells me I always have to go talk to a lawyer anyways. Why not just go to the lawyer in the first place? So just be careful out there. The takeaway here is know when to ask the right questions and know when to get your help.
Excellent. And so if anybody needs to reach John or I posted our email addresses, and I just posted them again. So, follow up with us. John posted the email or the website for WALA, which is waladc.org. And let me see, I do want to mention the Creative Entrepreneurship Series. So WALA offers an online creative entrepreneurship series. If you found this helpful, there's a whole set of different things just like this, where you have people who are at the top of their field talking about all these different elements. And so it's very helpful, and it's very worthwhile. It's one of the most cost-effective.
You'll get to hear me talk about copyright and trademark for 2 hours.
Yeah. All right. And so now I'm going to leave you with these words. And so if there's anything that you take away from our conversation today, I want you to take away what I'm about to tell you. The first and most important thing that I will say is talking about mentorship. You need to find mentors. Anything that we're talking about today, if you find the right mentor, they're going to help you leapfrog so many problems. They're going to help you avoid bad things, steer towards good things, and have a much more rewarding career. Now, the other side of you finding mentors is you now have an obligation, once you've found a mentor, to also become a mentor. You need to pay it forward. And so finding mentors and being a mentor is something, if you're not doing in your specific creative pursuit, is something that you need to start tomorrow. If you're not yet being mentored and or mentoring someone, you start tomorrow. If you need a quick place to find a mentor, go to SCORE, Service Corps of Retired Executives. It's sponsored by the Small Business Administration. It's totally free. You can find people who say, yeah, I want to be mentors. If you want to become a mentor, Big Brothers, Big Sisters, or a whole host of other places, call a local high school and see how you can get involved there. All right. Related to mentorship is volunteering. If you want to be somebody in this field, whatever field that is, you start volunteering in that field. All right. And related to all this is network. The only value that you have in the world as a creative professional is the value of your network, right? The people who you're able to, who speak with, collaborate with, run ideas through. And so part of that is building your audience. And so showing up to DC Shorts, showing a film here, being part of this community, that's a great way to build your audience, but you need to go above and beyond that. You need to have the Twitter, the Facebook, the YouTube, whatever the platforms are. You need to build your audience, because the sad truth is at this point, no one's going to come along and discover you and make your dreams a reality, right? The odds of that happening are less than you getting struck by lightning. You need to build an audience so that you can then continue to go to higher and higher and higher levels of distribution. People don't like to take risks. So if you have an audience of 1 million people, well, then someone's going to go to you and be like, oh, well, I'll promote them and I'll bring them to an audience of 10 million people. So you need to start building your own audience. And then the final word that I'll leave you with on this is come up with a plan. Like, so many of our clients are really talented. And so they're actors, they're writers, they're dancers, they're painters, they're computer programmers, and they're chefs. And it's great. It's inspiring. It's amazing. But it's very hard to move the ball forward with all of those simultaneously. So look at yourself in the mirror, go on a camping trip, start journaling, and from all these things that are your passion, that you love, distill one single pursuit that is going to be your starting point. This is what I'm putting my creative passions toward. You can re-examine in a month. You can re-examine in 6 months. You can totally pivot and change, but pick a passion. Dedicate yourself to it. Put everything you can about learning it, mentoring, building your network, supporting that single passion. And then take firm, decisive action. On that note, on behalf of myself and John and the Walla family, we greatly appreciate the hospitality of Peter and the DC Shorts team. This has been so many years of a healthy, happy, amazing collaboration. It is an honor to speak with every one of you guys. It's an honor to call Peter our peer and our friend. And so thanks for having us, guys.
Thank you.
Brian and John, thank you both so much. You're incredible. And I hope everyone enjoyed hearing and learning everything I did today as much. So thank you.
Hey, have fun at the festival, everyone.
All right. Bye, guys.
Bye.
Bye-bye.